Hey everyone, it's Rob Ryder. It's November 19th, 2012, and this video is going to be on little bits and pieces. Just some interesting things I found in the last week, and still haven't fit them all together, but first of all, we got to know that they exist. So one of the things about the courts is there's really two jurisdictions. You have the jurisdiction of law and you have the jurisdiction of equity. Two different forms of law. It may be administered by the same people, but it's two different forms of law. And when they use law, what they care about is what the customs are, which is the traditions, and what the legislature says, which is like this MCL, Michigan Compiled Law. Where equity is there to take the rough edges off the law, because here's one of the things that the law says. So if we went strictly by Michigan compiled laws, birth registration required, a birth of record for each live birth that occurs in this state shall be filed at the office of local registrar not more than 5 days after birth. The birth shall be registered when the filing is completed. All right, well, that sounds simple enough, right? Not that one. So you probably can't see this very well, but this is my certificate of live birth. And if you look down here where this damn nitro thing is, first of all, my birth date was September 5th, 1958. That's up here, September 5th, 1958. And down here it says, received by local registrar, September 18th, 1958. Well, if he didn't receive it until September 18th, that would be 13 days. That, seems to be longer than 5 days. And then when you go further into this, you'll see that there's these delayed birth registration forms, right? But what's really happened then is if this is, truly what happened, didn't get there within 5 days, hasn't been properly done, right? The law doesn't care. This is what the law says right here. So basically, they don't see me as live. Possibly, right? We don't really know how they're using the system, but here's one of them that they could be using. And so there is a way to do a delayed birth registration form. I haven't really looked into that yet, but here's a case of where a law would say, well, it wasn't done, so you haven't been registered as being alive. Law doesn't care. That's what the law says. Doesn't matter if you walk in and you're alive. You weren't registered as alive. So, enough on that. That's something to be looked at a little bit more later. But mainly this is, I sent an email out talking about these documentary stamps. And, through this journey I get a chance to talk to a lot of people, all different court cases and so forth. And while I don't always understand the cases, I'm looking for what they say is happening. And, they said, yeah, they're looking at the back and the front, and they keep flipping my paper over, and then they say they can't see my paper, and so forth and so on. Well, I'm sure they can. It's sitting right there. But the law is going to say that you have to have a documentary stamp on it, it looks like, for it to be lawful. So, where'd this stuff start? So the Stamp Act of 1765, Parliament attempted to raise money through direct taxation on colonies for the first time. The act required that all sorts of printed material carry a stamp, including purchase from a government agent. And this went on newspapers, court documents, commercial papers, land deeds, and the like. Dice, playing cards. Well, we all know that playing cards still have a seal on them, and a pack of cigarettes has a seal on them, and a bottle of liquor has a seal on them. We think of them as seals, but what they are is revenue stamps. And so this was a national revenue stamp imposed by the British government, and it's supposed to be one of the reasons they give for why we had the Revolutionary War. Who really knows, right? Could have just been part of the plan. And it was passed some more, so the new tax was imposed on all American colonists and required them to pay a tax on every piece of printed paper they used. Ships, papers, legal documents, licenses, newspapers, other publications. So the interesting thing here is this thing about newspapers, right? People say you put things in the legal section of the newspaper that it seems to have an effect. And that could be because that paper has been sealed. I don't know if you still can find the seal on the paper or not, but doing a little hunting over the weekend and, looking at images on Google, you could see where it was used, in times of old at least, on old newspapers. So if you don't have this on, and if you don't put these document stamps on your court documents and you put them into court, they're not lawful documents. You haven't paid the tax on the document. Well, what else can we find out here? So a revenue stamp, government stamp indicating payment of tax on commodity, such as alcohol or tobacco. Well, technically paper is a commodity. And a revenue stamp, tax stamp or physical stamp is usually adhesive label used to collect taxes on fees on documents, tobacco, alcohol, drinks, drugs, medicines, playing cards, hunting licenses, firearm registration, and many other things. So we get these document stamps for other things, right? But we need to go find out, do we need to have them for our documents to put into court to make them lawful? Now, if we need to, well, so do they. And think about all the pieces of paper you've seen in a court case. They don't have any document stamps on them. Typically, businesses purchase stamps from the government and attach them to the taxed items as part of putting them on sale, or in the case of documents, as part of filling out the form. Right? So it seems to apply to documents. A revenue stamp often look very similar to postage stamps. And in some countries and at time periods, it has been possible to use postage stamps for revenue purposes. But not now. Or at least not for the state. You use a postage stamp, that's a federal. And these revenues are for state revenues. And so you need to use the state's revenue stamps. And does it still exist? Well, in Florida, in one of their statutes, 201.12, Clerk of the Circuit Court shall report to the Department of Revenue the names and addresses of all individuals, firms, corporations who shall fail to have affixed either the required amount of stamps or a notation that the proper stamps and amount of stamps have been paid or will be paid directly to the department on any conveyance or taxable instrument or document which may be recorded in their respective offices, right? Taxable instrument or document which may be recorded in their respective offices. So to have it recorded, instead of just registered or filed, you have to pay the tax stamp. Documents taxable generally. There shall be levy collected and paid, the taxes specified in this chapter, for and in respect to the several documents, bonds, debentures, certificates of stock, and indebtedness, and other documents, instruments, matters, writings, and other described in the following sections, or for in respect of the vellum, parchment, or paper. Hell, you got to put a document stamp on just because you're using the paper. And we're not, I don't know anybody's putting stamps on their stuff. They may have tried it. Hell, I tried it with postage stamps, and you sign through it and cancel it. All sounds good. And it may have been the correct thing to do, but it was the wrong stamp. Any tax specified in this chapter shall be paid by a non-exempt party to the document. The documentary stamp taxes shall be paid on all recordable instruments requiring documentary stamp and according to law prior to recordation. One of the things we're trying to do is get the documents, for those of us that are trying to get out of the system, and I don't mean to get out, I mean to get into the living book instead of the dead book, is you need to have your documents recorded in the office of the recorder, because what's ever in the office of the recorder is the law. And the office of the recorder is, in my opinion, in the chancery, which is in the court, which is part of probate, which is the court of the ordinary, which is a power that the bishop has delegated to a certain judge. And the reason I say probate is because probate has exclusive jurisdiction over trust and estates. Your all capital letter name is an estate, and you put it into trust, possibly. And a trust is an unexecuted use, which means whoever you gave it to didn't sign the damn contract and send it back to you. So it's really not a contract, it's a gift. And you're trusting them to do the right thing with it. And they're not. So we want to make it lawful that it's ours. Because the law says that they're holding the legal title, they're the owner. Doesn't matter how they got it. And so you can't go to law because they're holding the legal title to everything. And because of the rigidness of common law, if they're holding the title, they're the legal owner. But you still have equitable title, and so you can go to equity for an equitable relief. And equity will trump law if the keeper of the king's conscience, the chancellor, looks at it and says, yeah, you're right. I got up early to do this and the phone still rings. With respect to mortgages or deeds of trust which do not incorporate the certificate of indebtedness, the notation shall be made in the note or certificate of the tax has been paid on the mortgage or trust deed. With respect to mortgages or trust deeds which do not incorporate the certificate of indebtedness, a notation shall be made on the note or certificate that the tax has been paid. So, even if they're not on there, but it's been paid, has to be noted that it's been paid. So here's some interesting things. So stamp tax, ad valorem or flat tax levied on certain legal transactions such as transfer of a property, copyright, land, patent, securities, documents evidencing such transactions are recorded and become legally enforceable only if they are stamped to show the proper amount of tax has been paid. Also called a stamp duty. Okay. Well, you get charged for ad valorem taxes all the way, and this all the time, called property taxes. This is saying it has to have a document stamp on it to be legally enforceable. You may want to ask your property tax man, well, where's the document stamp, and see what he says. And, it looked like all states have some version of a documentary stamp. It takes a little bit of hunting to find, but not too much. So the easiest thing to do is go ask the county treasurer for a document stamp for your court cases, or go buy a sheet of them, or whatever it takes. If they say, well, they don't think it applies or whatever, then say, well, then get out your tax exempt stamp and put it on here for me. Make them put a stamp on it, or buy the documentary stamps. The proper amount of state stamp taxes must be affixed to an instrument before it can be recorded. Again, not registered, recorded. We want to get it recorded. Registered means it's still on deposit, and we're trying to get it recorded so that the record reflects what we want it to reflect. Oh, and they had this stuff called stamp paper. It refers to and often foolscate piece of paper which bears pre-printed revenue stamp. Stamp papers are not a form of postal stationery. They use a stamp paper. The use of stamp paper in American colonies was unpopular and credited for sowing the seeds of American Revolution. Back to the Stamp Act. Stamp paper was widely used around the world to collect taxes on documents requiring stamping, such as leases, agreements, receipts, court documents, and many others. The papers, so you're going to see this is the 8.5 by 13.5 paper. Right? It's one of the reasons you don't see that anymore, I guess. The papers are bought blank apart from the pre-printed stamps and are available from stationaries, lawyers' offices, post offices, courts according to local regulations. So first of all, do we need to put it on the foolscape size paper, and do we need to put the stamp on it? To me, I guess, right, if it's 8.5 by 11, as long as it has a stamp on it, you still pay the tax for the paper. And foolscape folio, 8.5 by 13.5. Okay. It's actually 17 by 13.5. So let's go on. So in Florida, documentary stamp tax is levied at this rate of whatever it is. The tax is usually paid to the clerk of the court when the document is recorded. Is payable by any of the parties to a taxable transaction. if one party is exempt, the tax must be paid by the non-exempt party. And somebody sent me this case after I'd sent the email out that this is a Florida case, 727 SO.2D 302 1999, where it was brought up that the note did not have the documentary stamp affixed, and Mr. Soma did not offer any evidence that the tax due on the note had been paid. Right? Didn't have a receipt to show that had been paid, and there were no seals on it. And they went on to say the tax and promissory non-negotiable notes, written obligations to pay money or assignments of wages, other compensation, exceptions. 1, the mortgage, trust deed, or other instrument shall not be enforceable in any court of this state as to any such advance unless and until the tax due thereon upon each advance that they have been made thereunder have been paid. I had to have a stamp on it. Okay. So let's see where we need to go here. So here's in Michigan, right? Real estate transfer tax. An act to impose tax upon written instruments which transfer any interest in real property, to provide for the administration of this act, and to provide penalties for violation of this act. And we got certain things. Treasurer means the county treasurer. Value means current or fair market worth in items of legal monetary exchange. And I haven't looked that up yet to see exactly what that is. Does that mean money? Or does that mean negotiable instruments? And so this is where they may get us. Instruments executed within the state subject to tax. There is imposed, in addition to all other taxes, all right, so it's the all other taxes, like the tax on the paper, a tax upon the following written instruments executed within the state when said instrument is recorded. And it's contracts for sale or exchange of real estate, yada, yada, yada. A combination of foregoing and assignment of transfer thereof. The tax shall be upon the person who is the seller or grantor. So they're supposed to be paying this tax, this transfer tax. Well, it sounds like they're supposed to be paying the other taxes too, and some of the other taxes, again, could be as simple as the tax of the damn piece of paper. There is imposed in addition to all other taxes. Okay, so this has to do with all other taxes and this tax, is the way I read it. And so as far as this transfer, it's 55 cents per $500. All right, then it goes through a list of exemptions, and there's all sorts of exemptions that it doesn't have anything to do with. So, documentary stamps, purchase method of affixation. The tax imposed by this act shall be evidenced by affixing the documentary stamps to every instrument subject to the tax. So they're not, what tax are they talking about? Because it said, just, some taxes and then this particular tax. Documentary stamps shall be purchased only in the county in which the property is located. So you need to get the stamps from the county where the property is. The stamps shall be affixed in such manner that their removal will require, make it hard to take off. And then you initial it and date it, which people have done with other stamps before. That's all good. Just the wrong stamp. The state treasurer shall prescribe and prepare for use by the county treasurer adhesive stamps of such denominations and quantities that shall be necessary for the payment of taxes imposed by this act. So you get them from the county treasurer. Tax to be paid only once. Exemptions, new considerations. Any instrument which is evidence of indebtedness or of contract right shall be subject to tax imposed by this act only to the extent of the new consideration given thereof. Well, your signature is consideration. That's considered good consideration. It's better than valuable. It's your promise. So if there's new consideration, such as a signature going onto a piece of paper for a contract right, you'd have to pay the tax. Unless documented stamps are, as required by this act, have been purchased at the time of presentation by the party responsible for their purchase, Okay, so no written instruments subject to this act shall be recorded in the Office of the Register of Deeds, so they won't be recorded. Doesn't mean they can't be filed. To me, record and file are two different things. The stamps may be affixed to the reverse side of the instrument. If those stamps, in those cases where it's necessary to record said reverse side, the stamp shall be affixed after recording by the Register of Deeds. They're going to put them on afterwards. So it could be that these stamps are already on the back sides of your documents, but you're supposed to be putting them on the face. So, for instance, your warranty deed, thing you bought your property from, right? It may have the excise tax stamp on there, but what does it have the document stamp just for the cost of the paper? Are they separate? I don't know. Go ask them and have them put the stamps on it so it can be properly recorded. And then an affidavit attached to a written instrument under the provisions of this act shall not be recorded and shall be detached from a written instrument prior to recording of the instrument. Such affidavit shall be used for county funding, auditing purposes only, and shall not be disclosed to any other person. Okay, so, well, first of all, they're taking apart a public record. That's against the law. You can't frickin' detach an instrument from a recording. Right? If you take something to them, because this says the stamp shall be affixed to the face of the instrument unless the person specifically requests the instrument be recorded prior to affixing the stamps. Well, if you give them an attached document and say you want it recorded, you expected the whole thing to be recorded. This is saying that, in certain cases, they're going to detach an affidavit from a recording, and then they're going to keep it a fucking secret. Excuse my French. Okay, so here's where those other taxes come in, because I said other taxes, right? So personal property. This is in the General Property Tax Act. For the purposes of taxation, personal property includes all the following: all goods, chattels, effects within the state. That's pretty inclusive. All interest owned by individuals in real property. We could go ahead and read this if you want to find it and read it yourself. It's MCL 211.8. Michigan Compiled Laws. So it goes on and on, but here's definition. Goods, a term of variable content and meaning, and it may include every species of personal property. Meanings of goods is extended to include all tangible items. All goods, chattels, and effects within the state. Right? So all tangible items, if it's a piece of paper and it has your name on it, it's your personal property, you need to pay a tax on it. Also includes the unborn of animals. Those are goods. I wonder if that's what they consider us. What's an effect? To produce, to make, to bring to pass, to execute, enforce, accomplish. Effect, that which is produced by an agent or a cause, right? So if it's all your goods, chattels, and effects, pretty much anything that you're doing that you're signing your name to is your personal property. And if you want it to be lawful and put into court especially, it needs to have the tax paid on it, the property tax. Stamp tax method of collecting duties on certain transactions by means of validating stamp attached to the taxable instrument, which may be a judicial act, a commercial document, a transfer of property, or law proceeding. They all need to have a stamp on them. Such stamps is to be distinguished from postage stamp, which is not a duty. All right? It's not a frickin' postage stamp. Stamp duty is a tax that is levied on documents, including the majority of legal documents such as checks, receipts, military commissions, marriage licenses, land certificates. So, I don't know. Is this a receipt? Is this something we need to put something on? Put a stamp on? Or here's the certified copy of record of birth. We'll get in that in just a second, but I'm going to take a break just for a second and regroup. Well, let me finish this page. I'll get the other ones up. Let's see what else we got. Okay, and this was interesting in the General Property Tax Act 211.135, right? Recording of conveyances, tax certificates, accepted conveyances, register of deeds. If any deed, land contract, plat, or of any town site, didn't say township, it says town site, or village, addition to any town site, village, city plat, or other instrument for the conveyance of title to the property is presented to the Register of Deeds of the county of this state for recording and filing. The Register of Deeds shall require the following from the person presenting it. And so what this is showing in MCL 211.135 is all these certificates were supposed to have been recorded also. A certificate from the state treasurer or from the county treasurer of the county stating whether all the tax liens, titles held by the state or any other individual. Okay. A certificate of the tax due on the property have been paid for 5 years preceding the date of the instrument. A certificate from the city, village, township treasurer, which the property is located, whether there are any tax titles or certificates of title, shall be held by city, village, township, or other individual. So, you're going to the county, but you need something from the city. A certificate that all tax titles, tax certificates, or special assessments sold on the property to the city, village, township have been redeemed for 5 years preceding the date of the instrument. Okay, and it shall not be recorded if those aren't on there. So I don't know if they have been or not. I just, it's kind of a segue, but it's just one more thing that of what the law says, and since the law says it, if it hasn't been done, then whatever has been done so far isn't really lawful. So you're really not seen as the owner, my opinion, if these things haven't been done. And I had seen in the state of Washington, I think it was, that if you go and you register with the county auditor out there, transfer a property, within 90 days you have to go to the town and get some certificate from them to say that you've done that, or they're going to consider it abandoned. Okay. All right, that's it for that. Hang on just a second. Okay, I wanted to show this letter somebody sent me. All right, so this is a letter from this, whoever's going to. And this up here, the stamp, to me, is a document stamp. It's a 2-cent stamp that somebody signed across. All right, now they have one on the top, one on the bottom. I don't know why. So have the treasurer tell you it's their law. You're not asking for legal advice. You're trying to follow their law, and they have an obligation to tell you the procedure. So that's kind of what that would look like. And for something a little bit different now, we're going to go to this act here. Carrying on business under assumed or fictitious name. I talked about this last week, but this is an act in Michigan. It's 445.1. It talks about you have to have this certificate. Shall not carry on, conduct, or transact business in this state under an assumed name or under designation, name, or style other than the real name of the person owning property. Well, what's the real name? When you look up the definition of true and real name, it says the surname coupled with the given name. Surname coupled with a comma with the given name. That's what the real name is. So if you're doing business under this name, Robert Allen Rytlewski, instead of Rytlewski, Robert Allen, then you're using an assumed name, and you would have to go register this assumed name. And you would do it on a form like this. So this is for Kent County. Now, before we get into this, I think that this is the original of this. Because, as you'll see, this here So we're going to do the certificate, and we must pay them a fee of $6, right? So there's the first charge. There's a $6 charge, and later on there's a $10 charge. That's what the Act says. Okay. And it's good for 5 years. If you don't renew it in 5 years, then they can destroy the certificate. So get rid of that one. Done with that. Okay, so here's the certified copy of record of birth, right? This is recorded in the office of the recorder. Well, I, Stephen Toth, clerk of the County of Bay and the circuit court thereof. So first of all, he's using the title clerk of the County of Bay, which is different than county clerk, or they would have said the same thing. He's certifying that this is remaining in his office. It's remaining in the office of the clerk of the County of Bay, right? Down here, he signs it as the county clerk, which is different than the clerk of the County of Bay. Again, as far as I'm concerned, it's a different office. I think this one here is when he's in his office as the Registrar of Chancery, because in Michigan, the circuit court clerk is also the Registrar of Chancery, although we don't have chancery courts anymore. So let's look at this form. The name of the business. Well, first of all, the undersigned hereby certifies under these provisions that the following person now owns, conducts or transacts or intends to own, conduct or transact, or maintain an office or place of business in the County of Kent under the name designated or style set forth below. So you would put your all caps here. And it says the address of business. Well, if you go look up the definition of physical address of business, it will tell you, forgetting that this is in parentheses, that it's the road number and the road name. That is the address of business. They already know that it's in the County of Kent, state of Michigan, because this is where you're filing the form. So all they need is the road number and the road name. Simple enough. Okay, so you're going to put all caps up here. And I don't know if you need to put a comma, estate, comma, trust, just the name of the business, right? Comma, DBA, however, the name of the business. And then down here now, this is the name of persons owning. So you're either owning or you're conducting, transacting, or composing the above business, and the home post office address. They want your name and the home post office address. It says residence address. So when you look at this thing, my original certificate of live birth, what is the residence for my parents? It's the name of the city, which is where the post office was, and the state. And so I think here you would put, again, this is in parentheses behind there, I ain't paying attention to that. You would put the name of the city. So for me, it's Rockford. That's where the post office is. And the state. That's the home post office address. They didn't ask for your address. They want the home post office address. Okay, so here it would be, they want the real name of the person. So it's Rytlewski. This is where this name comes in. Rytlewski, comma, Robert Allen. And then, okay, is or is not a partnership signature. And now you're going to have it acknowledged. And after it's acknowledged, it's going to be authenticated. And see, this is by Mary Halbert, the Kent County Clerk. If you look at this one, how this was done, Stephen Toth, County Clerk, and the Deputy Clerk signed it. Right? The deputy clerk's going to sign this one. I have hereto set my hand on official seal at the City of Grand Rapids. Now, the City of Grand Rapids, that is the de jure name for Grand Rapids. This goes back to looking for the unincorporated federal districts, right? That's the de jure side, the City of Grand Rapids, compared to Grand Rapids being the corporate side. So I think even if you were to fill this form out, you still need to go get the stamp. You got to get a stamp from the treasurer, or at least go ask him. And then it would get recorded in the office of the recorder, and this would now show you as the owner of the name. It would show that you're not the name. And if you don't have one of these on file and you're doing business under the name, such as signing your check that has your all capital letter name up in the upper left-hand corner, and you're not registered to do business, well, then you're breaking the law. And again, this act goes in deeper. I already did a video on this. I'm not going to spend a lot of time on it, but Act 107 in 1907. You have to do it. You have to do it every 5 years. And then you have to pay another fee of $4 to have it renewed. If you don't renew it, they're going to abandon. Shall, on that date, constitute abandonment of assumed name. Well, you abandon the name, then you abandon the accounts, and somebody else can come in and try to claim them. I'm thinking. 6 years after an original or renewal certificate has expired, the county clerk may destroy their certificate. Whenever assumed name concern has changed or changes its place of business, shall be the duty of the person to change the, wherever you go, you got to do this. This is, what this is determining your domicile for your natural and legal person. Excuse me, for your legal person. Which is a business, and you're the owner. So tell them you are. So on this form, go back to this form here. All right, I would put Rytlewski, Robert Allen, owner. Rockford, Michigan. That's how I plan on doing it. Okay. Just more about filing the form. Fictitious names. Okay. So the county clerk shall keep. See, now this is the small c county clerk shall keep an alphabetical index of all persons filing certificates. So they would put this under then Rytlewski, Robert Allen. And receive a fee of $10. Right? So you needed to pay $6 up here. Filing fee of $6, right? At the time of filing the certificate, the person shall pay the clerk a filing fee of $6. Simple enough. But then they want you to pay another $10. And on this form, filing fee $10. It doesn't talk about the $6 filing fee yet. To do it lawfully, when you take it to them, you got to pay them $6. So I don't know why they're not doing that, right? But I'm going to take the law in and say, well, it says I need to do this and this, and give me a stamp, and we'll find out where all that goes. So, now is this the one here? Yeah. The certificate referred to in Section 1 in the case of any person named in the certificate other than an individual shall state the nature of the entity, the statutory law, if any, under which it was organized, the place and date of filing with any governmental aid authority, identifying it of any documents describing them required to be filed in order to accomplish or complete the organization of the entity and to entitle it to operate or transact business under the laws of the state and if organized elsewhere of the state and county where it was organized. And if a fiduciary, the date of the last will and testament or trust agreement, and the court place date of admission to probate of will of the names and of the will or the name and addresses of the parties to the trust agreement. So you don't need to be dead, don't need to be probated. That was one. Or name and addresses of the parties to the trust agreement, and name and address of each fiduciary, and if a partnership, the name and address of each general partner. So if anybody other than an individual does this, and we're doing it as the individual, right? Because we're going to put our true name. That's going to make us an individual. Rytlewski, Robert Allen, I guess, is going to make it, and I'm going to tell them that I'm the owner. But if somebody else is using your name, they would have had to put all these other papers in. And since this thing is, here's the dilemma, right? When they index this thing, it sounds like they're doing it by this person's name down here, not by the name of the business. So if you go in looking for your name of the county clerk, the name of the business, it may only be indexed under the name of the person that signed down here. If that makes any sense. Not that any of this makes any sense. That's why we're going to probate, right? Because all these laws are keeping you, because one of the things is, so if you haven't done this, fail to file a certificate required by Section 1 shall be prohibited from bringing any suit or action proceeding in any courts of the state. They're saying you can't bring anything to court unless you've done this until after full compliance with provisions of this Act. Right? So again, the way I look at this stuff now, right? If you go and you want to get this form recorded, right? And they're going to tell you, well, we can't offer legal advice. I'm not here for legal advice. It's your form. It's a procedural issue. How do I properly do this to show that I am the owner and that it's properly recorded, not just filed? And if you don't like their answer, say, well, I'm going to take you to the court of inquiry, right? Where's the chancellor? We need to start bringing out the fact that we know that they work for the bishop. All these courts that have any jurisdiction in equity have it because the bishop has delegated his power to them. He is the chief judge of the diocese. He is the ordinary, right? But he can delegate it, and so he delegates limited jurisdictions to all these different courts, and the one that has the exclusive jurisdiction over trust and estates is the probate judge. And it's a probate judge who's on more than one time, when asked by people trying to figure out how to get their estates and so forth, well, you need to put in a case, or you need to have an informal status hearing, or whatever the case may be. And Brother Tom's trying it right now, right? It's sitting on his desk. We'll see what the judge says this time. But he's the one that told Rich last year, well, it sounds like you need to have an informal status hearing. So more on that as we go, but I'm just pointing out some things that if you've been putting things into court and they don't have document stamps on it, that could be the only thing wrong with your document. Everything else is fine. Right? The first page itself may have been enough. I know people like to write 50-page books, right? Because they're trying to figure everything out. But at the end of the day, if you don't have a document stamp, it doesn't matter. They can't see it. They turn right past it. Take it to the treasurer and say, I want to enter this in a court case. Is there a document stamp fee? And if there isn't, put on here with your stamp that this is exempt from taxes. Make him do it. So, okay, that's all I had for now. We'll see how this week goes. And y'all take care of yourselves. See ya.